Swayam Prabha. Digital India. Educated India.
So now we start with the final part, that is the dispute resolution. As we have discussed the different agreements that are covered under the WTO trading system, we cannot deny that there can't be the disputes or there cannot be the difference of opinion among the parties. So how that can be resolved? Now the very first thing is that should be highlighted here. The parties in the dispute settlement system, or let's say how the WTO resolve the dispute. Firstly, it does not allow any private body to come up with the disputes. That is, it's the always state that is one of the parties. So if there is a dispute regarding subsidies or subsidies being given to a particular company, or if it is dispute regarding the dumping practice being followed by a particular company, it is the state that will be representing. So it's the state versus the state. That in case of dumping, it will be like the products that are exported from that particular country to the country where they were imported. So it will be like state versus the state. Secondly, it's confined to the agreements that are covered under WTO. So something that is not covered under the WTO will not be accepted as a matter of dispute. For example, human right values, so they are not included. But sometimes there are issues that may not be directly covered in the form of agreement, but they can be interpreted to be to be covered under the wider domain of those agreements or the objectives of the WTO. For example, the environment perspectives. For example, it can be covered. Some of the issues can be covered under technical barriers to trade. Maybe they are concerning national security and safety. So on all these issues, the dispute settlement can give some decisions, or mainly in the environmental perspective, so far as the sustainable concept of sustainability is included in the preamble with regard to sustainable use of resources, and then exceptions of GATT Article 20, so they also give wider scope to the environment issues, and then something that can be derived out of sanitary and phytosanitary measures or technical barriers to trade. So like that, they have given decisions on environmental issues. Now coming to understanding on rules and procedure, firstly it has its own set of agreement. Like there are separate agreement on subsidies, dumping, TRIPS, or let's say technical barriers to trade, sanitary and phytosanitary measures. Likewise, there is a separate agreement on understanding on rules and procedure regarding the dispute settlement, and there is a big difference that has created a big difference from its earlier trading system, that is the GATT. In GATT system, that much of autonomy was not with the dispute settlement procedure. So mainly it was part of the GATT system, and the parties they were very much influenced by let's say the bigger economy or the smaller economy, because there was less autonomy. But in WTO system, realizing the fact that for the trust to be maintained between the parties, and no discrimination between the parties, whether it's powerful or having a higher economic potential, or the countries that have low economic potential or they are less in size of market, they should not get the justice, or they should not be treated fairly. That should not be the case in the WTO. So for that reason, separate agreement was included with separate set of rules. Now today we start with this the dispute settlement understanding. Governing the settlement of dispute is included in the WTO trading system through Annexure 2. Like there is one mainframe agreement of the WTO that is like the founding agreement, where it talks about how the WTO system works and what are the key aims and objectives of the WTO. In that mainframe agreement, there are various annexures like Annexure 1, Annexure 1A, then Annexure 2, 3, and 4. So Annexure 1A that deals with separate type of agreements. Now Annexure 2 that deals with the specific agreement regarding the dispute settlement bodies. Resolving trade dispute is one of the core activities of the WTO. As stated that when we have such a vast range of countries with different economic status, it's very natural that there are chances of the disputes on various issues. That means there has to be one special body for resolving those disputes. A dispute arises when a member government believes another member government is violating an agreement, that is the agreement that are part of the WTO mainframe agreement, or a commitment that it has made in the WTO. So when we can say the dispute arises, mainly there is a breach of agreement or there is a breach of any commitment made by that party to the WTO. Party here always means the state. The WTO has one most active international dispute settlement mechanism in the world. Since 1995, that means from its inception, 629 disputes have been brought to the WTO and over 350 rulings have been issued. The rulings here includes either from the panel's decision or the appellate body decision. Now here you can see the graph that gives some reflection about how it has been changing over the years. So we cannot say there is any hard and fast rule or any such, let's say, strict line to know about the number increase in whether there will be increase in the dispute per year or whether there will be decrease. But this shows this graph shows what extent the dispute has been there. Dispute has been brought before the dispute settlement body from its inception and what is the status till date, and not simply the disputes that has been brought, but the disposal of the disputes. Now this graph is mainly related to consultation. So what is consultation? Consultation is the first step of dispute resolution. That means when there is a disagreement between the parties and the first stage is to initiate the dialogue. That means they have not formally registered that they want a judicial process. So it is something prior to the judicial process. That means they based on through their own channels they want to resolve the dispute. But once the consultation process has started, that also need to be known to the WTO, so that if the consultation process fails, then only they will start with the judicial process. So that should be known to the WTO. Therefore, this regarding consultation also they keep the record. Now let's give a look to some historical developments, how this dispute settlement body came into existence. In 1994, members of what was then the General Agreement on Tariff and Trade. The Tariff and Trade, General Agreement on Tariff and Trade means the previous trade system, adopted a decision at their ministerial conference in Marrakesh, Morocco, to complete a full review of dispute settlement rules and procedures under the newly created WTO within the 4 years after its entry into force of the agreement establishing the World Trade Organization. So this was decided during the previous trade system itself that they need to have some concrete dispute resolution system. And while negotiations were going on between the parties, that how that should be evolved, so there they realized and they decided to create a separate judicial system to resolve these crises. Members were to take a decision at that time on whether to continue, modify or terminate such dispute settlement rules and procedure. Now the question was whether they will take the previous dispute resolution body, that is the dispute resolution body that was existing during the GATT, or they will make changes or they will modify it. Changes here means they will modify or simply they will terminate. Now it was realized that it should be more equitable, it should be more faster, effective, and mutually acceptable to all the parties. So in the light of these, or in this background, we need to have some new format for establishing this dispute settlement system. WTO members have agreed that if they believe fellow members are violating trade rules, they will use the multilateral system of settling disputes instead of taking action unilaterally. That is, multilateral system means where other parties are also involved. That means abiding by the agreed procedures and respecting the judgments. The procedure for settling disputes existed under the old GATT, but it had no fixed timetables. That means it took longer than expected, or unnecessarily the disputes were prolonged, and many a times it was like, because of prolongment of these disputes, the parties used to be severely affected in economic terms, so they had to bear losses. The procedure for settling disputes existed under the old GATT, but it had no fixed timetables. Rulings were easier to block, and many cases were dragged or inconclusively for a longer period of time. These were like the shortcomings of the previous dispute settlement. The Uruguay Round Agreement introduced a more structured process with more clearly defined stages. So now, realizing what were the shortcomings, so they wanted it a more structured, then clearly defined stages for knowing what time period will be taken by each particular stage, so that the parties, they do not suffer much losses because of the delay. It introduced great discipline for the time a case should take to be settled within the flexible deadlines as in the various stages of the procedure. So minor flexibilities were like allowed, but then it must be finally resolved within that extended period of time. The agreement emphasized that prompt settlement is essential if WTO is to function effectively. That like is the primary thing. The member states won't have trust in the institution if they find the dispute resolution body not working effectively, or they realize that it's a time-taking thing. So realizing this fact, the WTO has to prepare itself. The provisions that has to be included for the provisions that have to be included for structuring the dispute settlement body, for demarcating its role, and also for its functionality, must consider the time factor as an essential criteria. It sets out in considerable detail the procedures and the timetables to be followed in resolving dispute. If a case runs its full course to the first ruling, it should not normally take more than about 1 year, 15 months if the case is appealed. So the maximum time that is expected in case of the case is 12 months. But if it goes for appeal, that means if it goes to the appellate body, then it can take 3 months extra. The agreed time limits are flexible, and if the case is considered urgent, now it could be that the case need to be dealt with urgently. For example, in case of perishable goods like the food items, they do have the expiry date of short duration. So in that cases, the decision must be faster, and it must be time bound. It is accelerated as much as possible. The Uruguay Round Agreement also made it possible for country losing a case to block the adoption of the ruling. Now, what was the new thing added? The Uruguay Round Agreement made it possible for country losing a case to block the adoption of the ruling. Under the previous GATT procedure, ruling could only be adopted by consensus, meaning that a single objection could block the ruling. Here it was in the earlier practice was that any single country can block the ruling given by the court, by this dispute settlement body. But now it is not the case. It's not the ruling cannot be blocked by the single country, but it has to be based on some consensus. So now the rulings are automatically adopted unless there is a consensus to reject a ruling. That means once the decision has been given by the lower body, that is the panel body, and there is a time given to the parties to accept it. If within that time period either they accept it or they go for appeal, and if they do not go for appeal, that means they must comply with it. And if they do not want to comply with it, it can't be unilateral decision, so they had to accept it. And if they want the ruling to be blocked, that has to be done through consensus. Earlier it was any single party can block that ruling. Now the rulings are automatically adopted unless there is a consensus to reject a ruling. Any country wanting to block a ruling has to persuade all other members, including its adversary in this case, to share its view. So that has to be by large number of member states. They ready accept that this ruling should be blocked. The preferred solution is for the countries concerned to discuss their problems and settle the dispute by themselves. So what is the easy and effective method here? To start with consultation process and take consultation process seriously. That is the first step. So before the case is registered for judicial process, the case is registered for consultation process. It is not that the consultation starts again in a very informal manner. Of course the process is a bit informal, but again the consultation is also registered in the WTO system. So firstly it is registered for consultation, and at that time there won't be any judicial process. So there will be wider chances to resolve the dispute by means of consultation. The preferred solution is for the countries concerned to discuss their problems and settle the dispute by themselves. The first stage is therefore consultation between the government concerned, because they are very clear that it won't be time taking, and it is in the benefit of the parties also, or it is in the interest of the parties to save their time. If they go for the judicial process, then that will be time taking. And even when the case has progressed to other stages, consultation and mediation are still always possible. So this is something permissible even at the later stage, that the parties, if they realize at the time when the matter is at the panel stage or at the appellate body stage, that they can settle it outside this judicial system, or they have realized where the problem lies and either of the parties have agreed to resolve through their own choices. So they can do that, and that is possible here in the WTO system. That is through the consultation and mediation, it is always possible. Now how long a dispute takes, like comparing this with the GATT system, as stated, GATT system was not having any such time frame. So therefore the parties, they lack the trust. But when we talk about the WTO system, there is some mentioned time frame that we expect within that much of time period it will be resolved. So these are some listed, there is a list of this the time period that we expect the dispute settlement body to resolve the disputes. These approximate periods for each stage of a dispute settlement procedure are target figures. The agreement is flexible. In addition, the countries can settle their dispute themselves at any stage. So what is this? 60 days consultation, mediation, etc. That is the first step. When the parties realize that, let's say there are two countries and there is a dispute with regard to subsidies. That means let's say country A is exporter country. It exports its goods to country B, and country B also produces the same product which country A is exporting, and country B finds that the price of that product is lesser in comparison to its original price, and it realizes or it doubts that the lower price of that product is because of the subsidies being given by country A. So that is like the contention. So how that can be resolved? That can initially that can be resolved by means of consultation. That means it starts a dialogue. Country B starts a dialogue with country A that country A must consider whether it's giving the subsidies for the export of that product or not. So that kind of thing. it 60 days are permissible. Now, how the counting takes place? Because as stated to you earlier, that consultation process is although informal, but it is again registered with the WTO. So the WTO knows that some issues are involved between these parties with regard to these matters, and they have started the initial process of consultation. Mediation, that means another party can mediate to resolve this crisis, etc. And the time period is 60 days. So after this, if the parties are not satisfied, if they think that they will not be able to achieve the results by means of consultation, or they could not find any solution by means of consultation, so what could be the next stage, or what could be the result for this? So there is a time period for 45 days, that is the panel setting and panelist appointed. So they will again move to the dispute settlement body of the WTO. They will register that the consultation process is not successful. They must notify this. The first stage consultation process is not successful, and they want that the panel should be set up, panel body should be set up. So then it takes around 45 days for the panel body to be set up. That means the panelists to be appointed by the dispute settlement bodies. There are the bodies that actually set who will be the panelist. So it takes around 45 days for the panelist to be chosen. Then is after the panelist, then they will look into the matter. So how they will look into the matter? They will prepare the report. So it takes around 6 months from the day the panelists are appointed to the final report that is submitted to the parties after hearing, giving chance to both the parties. But in between this final report, there is one stage that is known as interim report. So they also give interim report is submitted by the panelist to confirm whether all the facts and all the details stated by the parties are correctly recorded or not. So that is also one part of the procedure where the panel body, before giving the final report, shows the details of the facts, shows the detail of the legal issues, that is with the panel body, to the parties concerned to verify whether all that has been recorded is correct or not. So after that, it takes around 6 months altogether from the day panelists are appointed to preparing the final report. Then is final report is then sent to all the WTO members, that is for 3 weeks time period. That means the WTO members have 3 weeks time to comment on that report. After that, it within the 60 days it adopts the report if no appeal is made. So once the report is adopted by a dispute settlement body, it is now expected that the parties to the dispute, they must comply with what is stated in that report. Now within that period, it's a total time period is about 1 year, and if there is no appeal, that means the report that is given by the panelist, the report adopted by the dispute settlement body, all together takes around 1 year. Now if it is appealed, that means the decision is not acceptable to the parties, decision given by the panel body is not acceptable to the parties. What is the recourse, or what else is the judicial process left? So they will go to the higher appeal, that is to the appellate body. That is again from 60 to 90 days period. It takes around 60 to 90 day period for appealing the report, and then the dispute settlement body will appoint the appellate body, and either within the 60 days they have to complete the report on the matter that is filed before the appellate body. So appellate body has the time for 60 days. If they think that they cannot prepare the report within 60 days, then they may take another 30 days. So 90 days time period where the appellate body has to prepare the report, and then it is sent to after this 90 days period, it is sent to the dispute settlement body for its adoption. So it remains with the dispute settlement body for the 30 days for its adoption. So total takes these 3 months extra, so that turns out to be the 15 months if the matter has been appealed. First stage, let me elaborate it. First stage is consultation, that is up to 60 days. Before taking any further action, the countries in dispute have to talk to each other to see if they can settle their differences by themselves. If they fail, they can also ask the WTO Director General to mediate or try to help in any other way. So along with this consultation thing, that is the 60 days time period, they also can request the WTO Director General to mediate or help them. Second stage, that is the panel stage, as we discussed, that in case the consultation stage is not successful, the panel up to 45 days for a panel to be appointed plus 6 months for the panel to conclude. If the consultation fails, the complaining country can ask for a panel to appointed. The country in dock, that is the other party, can block the creation of a panel once, but when the dispute settlement body meets for the second time, the appointment can no longer be blocked unless there is a consensus against appointing a panel. So here one has to be careful regarding the appointment of panel. So when can who can block the creation of panel? That is the party in dock, that is the other party. They have the chance to block the panel for once, and later on the dispute settlement body, if it meets the second time for the appointment, then it cannot be blocked until unless there is a consensus against the appointment of that panel. Second stage, the panel up to 45 days for a panel to be appointed. That is the time period within which the panel should be appointed, plus 6 months for the panel to conclude, that means to prepare the report. If consultation fails, the complaining party can ask for a panel to be appointed. The country in dock can block the creation of the panel once, but once the dispute settlement body meet for the second time, the appointment can no longer be blocked unless there is a consensus against appointing the panel. The panel's final report should normally be given to the parties to the dispute within 6 months. So within the 6 months time period, the report should be delivered to the parties by the panel body. In case of urgency, including those concerning perishable goods, the deadline is shortened to 3 months. So the minimum time period the panel can take for preparing the report, for example, in case of the perishable goods, it can be 3 months, but the maximum is up till the 6 months. Before the first hearing, each side in the dispute presents its case in writing to the panel. So how the process starts? Both the parties, prior to the first hearing, they will prepare the documentation and submit it to the panel. First hearing, the case for complaining country and defense. That means the party who feels that his rights are affected, they will make the complaint. Firstly, during the time of first hearing, the complaining country or the countries, what do we mean by the term countries here? Let's say because of any measure adopted by a particular country, the rights of 2 or 3 countries are affected. For example, let's say there are 2 or 3 countries exporting we put it like this. There are country A, B, C as exporting countries. To country D. So they are exporting a product to country D, and here what happens, the country D is also producing the same product, but country D has it provides subsidy to that product. So because of the subsidy, the price has reduced. Since the price has reduced, because of the reduction in price, the sale of goods from country A, B, C has affected. The sale of goods from country A, B, C has gone down. Let's put it like this. Now in this case, the matter is brought before the dispute settlement body, and we start with the panel stage. So in panel stage, it won't be how many countries will be there against country D, that is the 3 countries, because all of them are getting affected, because they have to face the competition in the market where the price of the product that is the product that is produced by country D, is artificially reduced. So in that reference, they all will be the parties here. What do we mean by the term country here? So if one side first draft, the panel submits first hearing. The complaining country or the countries, the responding country, and those that have announced they have an interest in the dispute make their case at the panel's first hearing. So all they will make the case in their first hearing. Then are the rebuttals, that is, the countries involved submit written rebuttals and present oral arguments at the panel's second meeting. After that, experts. If one side raises scientific or other technical matters, the panel may consult experts or appoint an expert review group to prepare an advice report. Now, what do we mean by expert? Let's say it's the matter that is related to sanitary and phytosanitary measure, or it is the matter that is related to some core economic aspects that is not included, or that is not that the panel body, they don't have an expertise. So how they will be able to know what is the exact situation? For example, country A is claiming balance of payment crisis, and the panel does not have the expertise to know whether the country A is in true sense facing balance of payment crisis. So in that case, they will appoint a body of experts, or they will seek the advice from the body of expert to know whether in true sense there has been a balance of payment crisis in that particular country or not. Likewise, they will seek the advice from an expert to know something about sanitary and phytosanitary measure, whether there in true sense those standards are met or not. So that is what we mean by experts here, that can be outside the panel body. If one side raises scientific or other technical matters, the panel may consult experts or appoint an expert review group to prepare an advisory report. First draft, the panel submits the descriptive, that is the factual and the argument section of its report to the two sides once the first draft is ready, giving them 2 weeks to comment. This report does not include finding and conclusion. So that is like something prior to the final report, that mainly to verify the factual information, to verify whatever has been given by the parties that has been correctly recorded there or not. Interim report, the panel then submits an interim report including its finding and conclusion to the two sides, giving them 1 week times to review. So after that, whatever decision, that is interim report is again not the final report, but that is includes conclusions and suggestion, and it is again to check and verify whether all the things have been rightly done or not. Review, the period of review must not exceed 2 weeks. During that time, the panel may hold additional meetings with the two sides. So that is the difference. Even if they have gone for this interim report, that also again gives them the chance, the panel body to do additional meetings with both the sides. Final report, a final report is submitted to the two sides, and 3 weeks later it is circulated to all the WTO members. So once the report is ready, final report is ready, it is given, the report is given to both the parties, and 3 weeks later it is circulated to all the WTO members. That means all the WTO members are now made known what was the matter, regarding how the matter has been decided, on what basis the panel has decided this issue, and what are the compliance for the parties. If the panel decides that the disputed trade measure does break a WTO agreement or an obligation, it recommends that the measure be made to conform with the WTO rules. Let's say the matter is regarding any policy frame, or any policy that is being framed by any particular country that in one way or the other breaks the WTO agreement, that goes contrary to the WTO agreement, because once the member state has signed the WTO agreement, it is under an obligation to fulfill those objectives listed in the agreement. So in case there is a breach in the sense that they have formed any policy, so then they must withdraw that policy altogether. That means the measure to be made to confirm the WTO rules. That means, or let's say if there is a lacuna in that policy, because of that lacuna they are not able to fulfill the objectives of the WTO. So in that case, that lacuna has to be fulfilled. And that can be suggested by panel also. The panel may suggest how this could be done. The word used is here may, so it can't be like the panel is bound to suggest, but panel may suggest. The report becomes a ruling. The report becomes the dispute settlement body's ruling or recommendation within 60 days unless the consensus rejects it. Both sides can appeal the report. So what is the effect or what is the legal value of that report? It becomes the ruling. That means like the judgment being given, and now it's for the parties to comply. Now that is within that, when it gets the status of the ruling, prior to that it has 60 days time period. The report becomes the dispute settlement body's ruling or recommendation within 60 days unless the consensus rejected. So within that 60 days time period before it becomes the ruling, either it can be rejected by consensus or there can be appeal by either of the parties. So that can be the way. So once it is appealed, then we cannot say that the panel report becomes the ruling. Ruling also means that it can be now cited in other judgments. It can be referred in other judgment that in this case the panel body has decided like this. So that can happen if within the period of 60 days no appeal has been made or there is no rejection by means of consensus. Appeal. Either side can appeal a panel's ruling. So whether it's appellant or the other party, they can appeal to the panel's ruling. Sometimes both sides do so, because it could be both the sides feel there is a wrong interpretation given on the law, or for some reasons they are not satisfied with the judgments. Sometimes both the sides do so. Appeals have to be based on points of law, such as legal interpretation. They cannot re-examine the existing evidence or examine new issues. So the appellate body has its own limitation, but primarily it is supposed to do the legal interpretation work, and mainly if the parties are not satisfied. Each appeal is heard by 3 members of the permanent 7 members appellate body set up by the dispute settlement body and broadly representing the range of WTO membership. Now that is like how the appeals are made and who belongs to the appellate body. So how the appellate body is constituted, there is always permanent 7-member body. It is like a standing 7-member body. Out of these 7 members, 3 are selected for a particular dispute, that the appeal is, there is a matter on appeal, and the 3 members out of these 7 members, they are given the task to take into consideration these matters. Each appeal is heard by 3 members of a permanent 7 members appellate body set up by the dispute settlement body and broadly representing the range of WTO membership. Members of the appellate body have 4-year term. So what is the term period of the members? It is for 4 years. Members of the appellate body, it is for 4 years. They have to be individuals with recognized standing in the field of law and international trade, not affiliated with any government. So mainly they are an expertise in the area of law and mainly in the areas of international trade, and they are not affiliated with any government. That means they are working independently in the WTO trading system. The appeal can, now what will be the effect of that appeal? The appeal can uphold, modify or reverse the panel finding. So it can either accept the decision given by the panel body as it is. It can modify, that means it can bring changes. Either it can bring minor changes or it can bring major changes, or it can reverse. It can totally altogether reject the decision of the panel body and go for totally a different view. Reverse the panel's legal finding and conclusion. Normally appeals should not last more than 60 days with an absolute maximum of 90 days. So mainly it should be decided, the matter in appeal should be decided within the time period of 60 days, and in no case it should exceed the 90 days period. So 60 to 90 days period is the time period for appeals decision. The dispute settlement body has to accept or reject the appeals report within 30 days. So after the decision is given, whether it's within 60 days after the decision is given, when the matter is on appeal. So that is like the appellate body has given the decision. So after that, what is the effect? Either the dispute settlement body accept it or it rejects the appeal report within the 30 days. So the dispute settlement body has the time period for 30 days to accept or reject it. And rejection is only possible by consensus. So it can't be that some members they want not to accept the decision given by the appellate body, but it is only through consensus that the decision given by the appellate body can be rejected. The priorities for the losing defendant to bring its policy into line. Now, what will be the effect? The losing member state, they should meet the requirements that are set by the appellate body, and that is like to bring their trade policy in line with the recommendations that are given by the appellate body, and it is given time to do so. So it can't be that they are like forced to do so immediately, but it could be they require a policy change, they require some institutional change, they require some new laws to be enacted to comply with those recommendations of the appellate body. So they can take time. So they are given time to do so. The dispute settlement agreement stresses that prompt compliance with recommendation or rulings of the dispute settlement body is essential in order to ensure effective resolution of disputes to the benefit of all the member states. Now it has been emphasized again and again that they should keep in mind the time framework, because that is very important when it comes to the rights of the party. So if the decision is given lately and then the compliance also takes a longer period of time, so that will not actually serve the purpose with which the dispute settlement body is functioning, or the main objectives of the WTO. If the country that is the target of the complaint loses, it must follow the recommendations of the panel report or the appeals report. It must state its intention to do so at a dispute settlement body meeting held within 30 days of the report's adoption. So within the period of 30 days period of the report's adoption, the losing party, they must report whether they intend to accept the decision and comply with it. If complying with the recommendations immediately proves impractical, the member will be given some reasonable period of time. But if they think that it will require some time, they need some more time, so they may request for it and they can get the time. If it fails to act within this period, it has to enter into negotiations with the complaining country or the countries in order to determine mutually acceptable compensation, for instance tariff reduction in areas of particular interest to the complaining side. So let's say if it again fails, or it is not able to comply with the decisions, then they can again go for the mutually acceptable compensation or mutually acceptable way out through which they can resolve this crisis. For that can be, for instance, tariff reduction in particular interest in the areas of particular interest of the complaining party. That means how the complaining party can be compensated, or how the complaining party can be their rights can be adjusted if they find that there has been some effect on their trade interest. So how that can be compensated, that need to be then decided based on the mutual agreement between the parties. If after 20 days no satisfactory compensation is agreed, the complaining side may ask the dispute settlement body for permission to retaliate. Now if they cannot create any mutual agreement, or they cannot go for any satisfactory compensation, the complaining side may ask the dispute settlement body for permission to retaliate. That what can be the countermeasures taken, what it can do in retaliation for non-compliance of the decision. So there has to be some retaliation. Body for permission to retaliate, that is to suspend concession or other obligations. So if it is like a developing country, so developing countries, they get many kind of concessions. So in that case, those concessions can be denied, like the flexibilities that are given to the developing countries, so that can be denied. Or if not, then there can be restrictions on the sale of product. So like if there is a developed country which is not complying, so what will be the effect? And they cannot reach to the agreeable compensation point. So then the goods that are exported from that particular developed country, they can be restricted, or the WTO by consensus can pass an order that the goods from country A, the developed country, will not be used for the trade across the nations. This is intended to be temporary to encourage the other countries to comply. Basically, it is not on a permanent basis, but for a temporary purpose to make this as a reference point, or make this as an example that in case of non-compliance, some strict measures can be taken by the WTO. This is intended to be temporary to encourage the other country to comply. It could, for example, take the form of blocking the imports by raising import duties on products from the other country above agreed limit to the level so high that imports are too expensive to sell within the certain limits. The dispute settlement body must authorize this within 30 days after the reasonable period of time expires, unless there is a consensus against the request. So the dispute settlement body can do this within the time framework when the reasonable period of time for reaching the consensus has expired, unless there is a request for extension of this time. Members do not complete the review on time and the talks fail to advance. Now, let me also highlight that whatever we see in the WTO, that has been many times criticized, and the member states, they have asked for bringing the change. Now, such like change was also discussed prior to the Doha conference, and it was stated during the Doha conference that members do not complete the review on time and talks fail to advance after 1999 ministerial conference in Seattle. At their 2001 ministerial conference in Doha, where the Doha Development Agenda negotiations were launched, members agreed to continue the review on improvements and clarification to this dispute settlement understanding. Members also agreed that the review would not be the part of Doha Development Agenda. That means they wanted to not to club the dispute settlement understanding methods, the changes that are required in dispute settlement understanding methods, to be clubbed with other agendas that were discussed in Doha Development Agendas. Members also agreed that the review would not be the part of Doha Development Agenda single undertaking. That is, the review would not be tied to the other issues, or that will not be coupled with the other issues under negotiations, nor subject to the conclusion of the Doha Development Agenda. The Doha mandate also sets a deadline of May 2003 to conclude the review. So basically, Doha Development Agenda has listed lot of changes, and one of the area they have tried to bring changes is also dispute settlement understanding. But still that remains in limbo. That means the many parties have not agreed to the suggested changes that were highlighted, or let's say that were proposed during the Doha Development Agenda. A further extension agreed by General Council on 1st August 2004 without setting a new deadline was made. Now, what is the current work? How the dispute settlement understanding works presently? The dispute settlement understanding reviews is currently being carried out within the framework of 12 thematic issues covering broad range of proposals. So the areas where they want, or the member states in broad terms wants to bring changes, they are like, the proposed changes are in the areas of mutually agreed solution, like we stated that with regard to the consultation there has to be some more emphasis. So that is one such area. Third party rights, that is, the parties, they are not directly connected but indirectly their rights are affected. Third party rights. Strictly confidential information, that is like the data that is given or any such information that is given to the WTO during their the judicial process, or during the process of investigation. Sequencing post retaliation, that means when the parties are, due to the non-compliance, they are retaliating. In that case, what will be the effect after this retaliation period is over? Transparency and amicus curiae briefs. How to make this dispute settlement understanding more transparent, and the amicus curiae, they are those who are like friend of the judicial system of the WTO, but they don't have any personal interest. What role they can play in suggesting or in resolving the crisis. Time frame, again the time frame is a crucial issue here. Remand, panel compositions, flexibility and member control, effective compliance, developing country interest, including special and differential treatment that need to be taken into consideration while the disputes are resolved when the matter is between a developed nation and the developing nations. Since November 2016, the negotiating groups has undertaken work on these issues in a sequential and focused manner. Under this approach of sequential focused work, the chair holds a series of meetings dedicated to one of these issues, after which the negotiating groups proceed to work on another issue. The negotiating groups has already conducted focused work on several other issues. Ideas brought forward by the members and others in the context of these consultation, the so-called ZARA process, such as agreed page limits for executive summaries, time limits for oral argument, expeditious expert consultation in disputes concerning sanitary and phytosanitary measures, questions sent in advance of a panel's meetings with parties and third parties are being implemented by individual panels on ad hoc basis with the agreement of disputing parties in particular case. DDDA JARA's consultation were complemented by efforts within the Secretariat to promote harmonized practices more generally in respect of panel proceedings. Now comes the articles, some key articles that are listed in this agreement. The agreement here means the Dispute Settlement Understanding Agreement. Article 1, the rules and procedures of the understanding shall apply to the disputes brought pursuant to the consultation and dispute settlement provisions of the agreements listed in Appendix 1 to this understanding. So, when the rules become applicable, the rules and procedure of this understanding shall apply to the dispute brought pursuant to the consultation. So, once the consultation process starts, although it is an informal method, but the rules and the procedures that are listed in the WTO dispute settlement understanding, they come into the picture. The rules and procedures of this understanding shall apply subject to such special or additional rules and procedures on disputes settlement contained in the covered agreements as are identified in Appendix 2 to this understanding. To the extent that there is a difference between the rules and procedures of this understanding and the special or additional rules and procedures set forth in Appendix 2, the special and additional rules and procedure in Appendix 2 shall prevail. Now, within this dispute settlement understanding, there is Appendix 2, which covers the special rules. So, those special rules are like to be added. They need to be given special consideration. They are those additional rules are along with the general rules, and many a times those special rules are given primacy. So, they need to be complied with when the dispute settlement process is working. So, that is what it's clearly mentioned. The rules and procedures of this understanding shall apply subject to such special and additional rules. That means the general rules are subject to those special rules that are covered in Appendix 2 on dispute settlement contained in the covered agreements as are identified in Appendix 2 to this understanding. To the extent that there is a difference between the rules and procedures of this understanding and the special or additional rules and procedures set forth in Appendix 2, the special and additional rules and procedures shall prevail. So, if there is a choice to be made between the general rules and the special rules that are included in Appendix 2, what shall prevail? So, in that case, the rules that are mentioned in Appendix 2 as the special rules that will prevail. Initial consultation. At the request of former Director General Pascal Lamy, former Deputy Director General Alejandro Zara initiated in 2010 a process of informal consultation with the WTO members. So, while talking about the reforms, the reforms in the dispute settlement understanding, that has been going on in different time period. So, during the Director Generalship of Pascal Lamy, lot efforts were made to bring those changes, and the Deputy Director General during his time, Alejandro Zara, he took lot of initiatives, and that is why the process he has introduced, that is termed as Zara process of informal consultation with the WTO members, panelists, trade law practitioners and secretariat experts involved in the WTO dispute settlement system, with a view to exploring whether it is possible to find efficiency gains in the panel process so as to reduce the burden on members and the secretariat. Basically, when we talk about the too much time is taken, so to reduce the time, it is they want that much of the work is done during the consultation process. His overriding approach was that any improvement would have to be consistent with the existing rules and changes could be contemplated only if they had not involved amending the dispute settlement understanding. So, whatever changes this Alejandro Jara was proposing or was suggesting, he wanted that all that should be within the existing parameters that are set under the dispute settlement understanding, unless and until the major changes are acceptable by all the member states. Then is administration. The dispute settlement body shall have the authority to establish panels, adopt panel and appellate body reports, maintain surveillance of implementation of the rulings. That means they keep on record or keep on track whether the decision given by them are implemented or not, and further give the recommendation whether they are rightfully implemented or not, and authorize suspension of concessions and other obligations under the covered agreement. So, in case the nations fail to comply with those regulations or those implementation, then there will be suspension of the concessions and other obligations that are covered under the various agreements. With respect to disputes arising under the covered agreements, which is a plurilateral trade agreement example, an agreement on civil aviation, agreement on bovine meat. So, these are plurilateral agreements. So, the terms and conditions that will be guided as are listed in those plurilateral trade agreements. The dispute settlement body shall inform the relevant WTO councils and committees of any development in disputes related to provisions of the respective covered agreements. The dispute settlement body shall meet as often as necessary to carry out its functions within the time frame provided in this understanding. The general provisions, the members recognize that it serves to preserve the rights and obligations. So, the members have the faith that mainly this the dispute settlement understanding, it serves the purpose to preserve the rights and obligations of the members under the covered agreements, and to clarify the existing provisions of these agreements where there is a requirement of interpretation to be made on these agreements. The dispute settlement body work as a very competent body with having the jurisdiction to do the interpretation. Interpretation of public international law and rulings of the dispute settlement body cannot add to or diminish the rights and obligations provided in the covered agreement. But there is a limitation that the decisions given by these bodies or the interpretation made by the various hierarchical bodies within the dispute settlement understanding cannot by and large affect the rights of the parties. Now, with this, I am thankful for attending this lecture, and I hope that in future also we will have the discussions on other issues that are related to WTO. I thank you once again for being party to discussion on the WTO, or otherwise we can also use the term international trade. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.